So today we're going to talk about the child abuse and neglect system that I work in, which is the civil court process. And so I want to give a couple of disclaimers here. I've worked in the field for 20 plus years as a social worker, first with the child advocacy centers, and then the past 14 years with CASA. And so I know enough about the law and about child CPS policy to be a pain in the butt for everybody that has to work with me. But I'm not here to recite to you specific laws or specific CPS policy. I'm going to give you a few websites and things that you can look up if you're looking for exact language. What my goal to do today is to help walk you through the process so that when you're working with a family, you have a better understanding of what that family may be going through and how to assist them or direct them in the right place. So I've done this training, this Child Abuse and Neglect 101, alongside with our prosecutor and our CPS supervisors. We've done it in day-long programs. We've done it in half days. And today I'm going to try to cut it up and give it to you in a 1-hour presentation. So some things I'll spend some time on, some things I'm going to kind of go quickly through. As Sue said, you're more than welcome to put questions in the chat box. I am not monitoring the chat box. We'll take time at the very end to do your questions.
Okay.
All right. So like I said, today the goal is to help you understand from the referral process all the way through either reunification or termination of parental rights. There are several principles that guide the work of those of us that work within the court system, and I want to review those with you so that you have a good understanding of what it is that why we're making the decisions that we're making. So I'm sure many of you on the call today have children or work with children or have nieces and nephews and grandchildren. I want you to think about, how do you know what is in the best interest of your child? Okay. Parents typically decide what is in the best interest of their kids, and then they provide it to them to the extent that they can. Parents are usually their children's best advocates, but the child protective system has to intervene in families' lives when parents cannot or will not protect, promote, and provide for their children's best basic needs. So what is best interest? It's super interesting that best interest is not really defined. There's no legal definition. It's been debated for years. I think it's pending before the West Virginia legislature right now, coming up with a better way of describing best interest. But in my world, we look at best interest as a safe home, a permanent home, and getting to that in a timely manner so that we are cognizant of the impact that it has on children. Judges across the country use this best interest of the child standard when making decisions about child abuse and neglect cases. Another term that we utilize is this concept of minimum sufficient level of care. When a child has been removed from their home due to abuse and neglect, it is traumatic for a child. So what we want to do is we want to make sure that agencies work on trying to keep children in the home whenever it's possible to do so and when that child can be safe. Children should only be removed when parents cannot meet that minimum sufficient level of care. So the same standard that we remove kids for is the standard that we return children for. We don't create an ideal living arrangement that parents have to try to achieve. We're using this minimum sufficient level, so this bottom line standard for a child to return or remain in their home. So what are the things that we consider? We consider the child's needs.
Right. What'd you say?
We consider what the child's needs are. So is the parent providing for the basic needs? Food, clothing, shelter, medical care, safety, protection. We're looking at this emotional needs being met. Is there attachment? We're looking at the developmental needs of the child, their education, child with disabilities. We're also going to be looking at the community standards and social standards that are commonly accepted within your community and society. Why do we use a minimum sufficient level standard? It maintains the child's right to safety and permanence while not ignoring the parent's right to their children. It is required by law. There's a federal law that talks about reasonable efforts. A minimum sufficient level is possible for parents to reach. It provides a reference point. It protects at least somewhat from individual bias and value judgments. It discourages unnecessary removals or unnecessarily long placements in child care or in foster care. It's sensitive across cultures. So lots of different things for us to kind of think about when we're thinking about whether a child should be removed or is going to be returned. So some of the principles that guide child abuse and neglect laws, and these federal laws kind of shape the delivery through policies and money. So states are responsible for the child protection function, and federal regulations establish the policies that states have to use when responding to abuse and neglect cases. But first and foremost, we want children to be protected. We want them to be safely maintained in their home whenever that's possible. We want children to have permanency and stability. We want to have continuity of family relationships and connections being preserved. Families should have enhanced capacity for their children's needs. We want children to receive appropriate services for education, physical, and mental health needs. All right, so now thinking those principles are kind of guiding us in this conversation of what do we do when a child needs to be have an intervention. So a few things I just wanted to mention. I'm going to give you an overview of mandated reporter laws. I know some of you have sent in questions for me to address, and some of those were very specific in regards to is the doctor required to be the one that makes the call? And I'm going to talk about that a little bit, but I also want to give you some good comprehensive trainings that you can go to on your own. So there's two sites that I'm providing you here. One is handlewithcarewv.org. They have a mandated reporter course up on their website, and I encourage you to go and do that course. And then on the Team WV, so Team for West Virginia Children, they have a website, teamwv.org. And then you go down to the tab that says mandated reporter, and you can go through their slides there for more information as well. And then most counties in West Virginia have what we call a Partners in Prevention team. That Partners in Prevention team can point you in the direction of the person in your counties who can train your staff in mandated reporting. So up in my area up here, myself and several other women have been trained and providing training around the concept of mandated reporter. We have people that do Darkness to Light, which is a sexual abuse prevention program. We can come to your churches and your civic organizations and your agencies and talk to you about how to implement mandated reporter policies and procedures. That is a whole nother training. So I'm happy to give more information about that if you're looking for more. And then I also went ahead and included the code. Someone was asking for specifics. This is the first one there in the black ink is the code for child abuse and neglect mandated reporting. And then the second one, which is in yellow, but no black background on the bottom, that is the code for adult protective services reporting. All right, so who is required to report abuse and neglect? So anyone, of course, can report suspected abuse and neglect. If you have a concern about a family, you do not have to be a mandated reporter. But there are certain people who are required, and that is in this list here. So you have your medical, dental, and mental health professionals. You have your churches, clergy members, and anyone that works within those institutions. You have school teachers and school personnel, social service workers, child care, foster care workers, EMS. Somebody asked me about EMS is included in here. Law enforcement, humane officers, judges of all kinds, employees of the Division of Juvenile Services. But this one really stands out to me because I think a lot of people fall under this that might not even realize it. Youth camp counselors, employees, coaches, or volunteers of any entity that provides organized activities for children. That means every single coach, volunteer coach of the ball leagues, dance programs, your 4-H clubs, anything that is providing activities for children, they are mandated reporters. So I think it's important for us as parents, social workers, and professionals in the field that when we sign our kids up, we should be asking, do you guys have training for your staff? Have you created an atmosphere in your camp or ball league that protects children? And if they haven't, send them on to your partners in prevention team so that they can get the training. Up here, we train all the coaches and volunteers and organizations, and we've been training hundreds of people every single year. So where do you call? The Child Abuse and Neglect Hotline. This is the number. It's 24 hours a day, 7 days a week. And then for our serious physical abuse and sexual abuse, you're also going to be calling law enforcement. And we'll review that in a second. So I get questions about, am I protected if I make a report? And the law does say people that make a report in good faith are immune from civil or criminal liability. Okay, that does not mean if you are in a custody battle with your ex and you guys are constantly calling on each other, you might not be making reports in good faith. And so there could be prosecution in those. But for the most part, those of us that are working in our professions, or we notice something in our neighborhood, concerns that we have, we're making a good faith report and we are immune from the from being prosecuted or someone suing us or something like that. And then there are penalties for failing to report. And you'll see both the code here for child welfare for a child and then also for an adult. So if you are a mandated reporter and you do not call in that suspected abuse and neglect, you can be subjected to a penalty of both a fine and jail time. The timeline for reporting. So if you have reasonable cause to suspect that a child has been neglected or abused, or you observe the child being subjected to conditions that are likely to result in abuse and neglect, then you must report within 24 hours of suspecting the abuse and neglect. And then if you also believe that the child is suffering from serious physical abuse or sexual assault, then you must also report to the state police or any law enforcement agency having jurisdiction. Now, if you're saying to yourself, I'm not sure, who my law enforcement agency is, believe me, they'll tell you. They'll say, oh no, that's out of our jurisdiction. You need to call down to Glendale Police. So they'll tell you if you've called the wrong office. So you just call the law enforcement. They'll direct you appropriately. So again, 24 hours to report to the DHHR and that hotline number that I had up, and we can put it back up at the end if we need to. And also law enforcement if it's physical or sexual abuse. You do not want to assume that people are cross-reporting, that CPS is involving law enforcement. The requirement is on you to do so. So what happens when you call into that hotline number? In West Virginia, we have a program called centralized intake. Centralized intake is the call center where they have social workers who are trained to take down the information that you provide. So this is just a short list of the information that you would want to provide. Those websites I gave you with Handle with Care and Team for West Virginia Children, they have extensive information about, they even show you in the Team for West Virginia one, they'll show you the sheets, you could print them out and write down your notes and everything like that for information. So demographic information, description of the suspected abuse and neglect, current location of the victim, information about protective caregivers, information about the perpetrator, general functioning of the victim and caregivers, potential safety threats. What you want to do when you're providing the information to centralized intake is to help them understand why you think a child is unsafe. That's what CPS is looking for, the safety of the child. Child Protective Services is not designed to look at every family of at risk. Okay, there's lots of resources you can refer a family to if you think a family is at risk of abuse and neglect. Use your family resource networks and your child advocacy centers and your Gabriel projects and agencies like that to help provide resources to families. Centralized intake is looking for, is this child safe? I snagged this off of Prevent Child Abuse West Virginia's website. This is showing you the process that the call comes in. So once the call comes into centralized intake, they are looking for present or imminent danger. They're going to be, notifying a supervisor and working on the screening process so that they can immediately send someone out to a child who is in imminent danger. Other referrals are going to be screened out or screened, by a supervisor to determine whether, there's enough cause for it to be assigned for investigation. Child Protective Services, if you're not familiar, that is what West Virginia's CPS is called. So other states might be like a CYF or DCS, and we hear them all different types. But in West Virginia, Child Protective Services, or sometimes we say CPS. It's provided to families when children are abused or neglected by whoever is responsible for the care of the children. Child Protective Services is a blend of state and federal statutes and best practices for families. So when someone makes a report to CPS and then it's screened in and an intake person or investigator is going to be assigned to see those kids, they're going to go out and they're going to interview the children. They're going to do what CPS calls a family functioning assessment. And during this assessment process, the CPS worker interviews the child, the siblings, the parents, caretakers, alleged abusers, any person that has information about the suspected abuse. So let's say that the Child Protective Services worker goes out and interviews a family and believes that this family, that there is some risk in a situation that the child needs protection. They're looking at the caregiver's protective capacities. Is this caregiver able to provide a safe home for their children? Sometimes they need some services to kind of help bolster those protective capacities. Maybe they need to clean up the house. Maybe there's, lack of heat in the winter, lack of food. That CPS worker is going to put together safety plan. That might be a catchphrase that you hear. This safety plan is going to ensure that the child is safe while the parents are remedying problems within the home. Maybe grandma's going to take the kids for the week while they clean up the house, while they're waiting for their, going to call all the resources and get their gas turned back on. They needed to get to next week when their food stamp card comes back in. And so CPS is wanting to make sure that the children are safe while the family is rectifying what's going on. They're going to measure the progress in meeting these goals. and they have a little case plan, and they'll come back in 7 days maybe, and it could be a different time frame, but they'll come back and they'll see, have they remedied what they need to remedy. So in order for these open services cases to be closed, the child has to be safe in their home, and in order for them to close that case. So when do cases go to court? Most cases of child abuse and neglect do not require court involvement, but sometimes it is necessary to go to court in order to protect the child. The department, the DHHR or CPS, initiates the court involvement when the child is unsafe and can no longer be protected in their home. So remember, we talked about at the very beginning these guiding principles of best interest and reasonable efforts and minimum sufficient level of care. Those are the things that the DHHR must make sure that they've done everything that they possibly can do before they remove a child. So when it's no longer safe for a child to remain in the home with their parents, then CPS petitions the court to place that child into care. And that could be with a relative placement or a foster care situation. So the child's parents are unable to change the behaviors that threaten the child's safety. Then we go through a process, and we're going to talk about this process in a little bit, but we give them an opportunity to try to change the behaviors. And then if they can't do that, then we look at other permanent solutions for the child, such as adoption. So in these civil child protection cases, the decision to go to court is made by the Child Welfare Agency or CPS, and the prosecutor. So in West Virginia, your county prosecutor is going to be the one that represents the CPS agency. Criminal cases are initiated when a family member is going to be charged with a crime. We're going to see that on the next slide. So the decision to go to court, either criminally or civilly, is a very complex one. The benefits of court protection against and the punishment of someone who has mistreated a child must be balanced against the disruption of that parent-child relationship. It's not something that we want to jump in, and do without thoroughly working on services beforehand. All right, so the difference between civil and criminal cases, and I thought this was an important thing to share. So the criminal cases are the ones that make the TV and the newspaper and things like that you read about on social media when somebody has committed a crime against a child. So we see cases of sexual abuse. We see a parent who leaves their child in the car when it's too hot or too cold. Those types of cases make the news, and those are criminal cases. Criminal trials are when we're looking at someone who has committed a crime, and then they're going to be, they're going to go through the process of either proving their innocence or being found guilty. And then the court can order some type of fine, restitution, probation, incarceration, those types of things. The civil cases is where parents are working to keep their parental rights to a child. Civil cases are closed to the public. You can't go and observe a civil case. And these don't make the news. You don't know about the strides that are being made by CPS or by the family involved. The focus is on the status of the child. Has the child been abused or not? Civil cases give us the opportunity to make improvements. So we have what we call improvement periods, and that is when we offer the parents the services to help them make change that will change the situation that led to the removal. And then, of course, sometimes you're going to have both a criminal case and a civil case. For example, maybe a parent who has sexually abused their child will have a criminal case for that sexual abuse, as well as be in jeopardy of losing their parental rights in the civil case. And you could have a parent, say a dad sexually abused the children in the case, and the mom didn't protect them from that abuse, then the mom could be in jeopardy of losing her parental rights in the civil case, but maybe she's not facing criminal charges. There's two basic questions to ask when deciding whether we're going to initiate the court proceedings and remove a child. And this is, Child Protective Services and the prosecuting attorney, they're determining, is this child in clear danger of significant harm? Can the child's safety be maintained without the court proceedings? And the CPS has to try that first in most cases. There are a few exceptions to that. We're also looking at things like parental incapacity to care for their child. So maybe incarceration. I've worked cases where both parents were incarcerated. There wasn't someone there to watch the child. Do they have a mental or physical illness that keeps them, unable to care for their child? Also, maybe we have cases where using the leverage for CPS to, get someone's cooperation. Sometimes there's open cases, the parent is not cooperating. And then there are some situations where treatment is only available by court order and CPS needs to get involved. So many of you, as I've done all of these COPs with you over the past couple of years, I know work with parents. And I really like talking about the fact that although the removal process is traumatic for children, and we care a lot about working with the children through this process, I think it's important to acknowledge that parents have feelings too. And when we can acknowledge, that parents are going through some stages themselves when they're involved in the court process, it can lead to more meaningful contact with these parents. The training that I've done through our CASA program really talks about the stages almost in a similar pattern to stages of grief. And that means that people can go through all the 4 stages. They might do them in different orders, or they might just, experience a couple of these. But one is denial that this is happening. It shouldn't happen. I didn't do anything wrong. This is all a big misunderstanding. Another stage can be anger, anger at the system, anger at the reporter, anger at themselves, their partner. And then another stage can be sadness, just, extreme sadness to the point where, getting involved in, treatment and working with the providers on doing the things they need to on their improvement period is almost impossible. And then finally coming to an acceptance. One, I cannot do this on my own. I need assistance I'm going to work with a CPS worker. I'm going to get to know my attorney. I'm going to work, and do what I need to do so that I can get my child back. All right, so I am just going to go through the court process. I'm not going to spend a lot of time on any of the different hearings, but I do want you to know what that court process looks like so that you can best help families. So some of the things that we're looking at the right to reasonable efforts. We talked about that already, making sure that a family has the right to be able to stay together if they can do so and be safe. The families have a right to proper notice. They have the right to having hearings where they can put out on the evidence. They have a right to counsel, guardian ad litem, CASA. They have right to confront their accusers and to cross-examination. Who participates in these civil abuse and neglect cases? The child, the guardian ad litem, and if that's a new word for you, that's the attorney that represents the children. And in West Virginia, that's an attorney. It's not always in other states. The respondent parents, that's what we call the parents in the cases. So they're responding to the petition that's been filed against them. The attorney for the respondent parent, and each attorney is going to get their own, even if they're married or they're a couple, they're each going to have their own attorney. Child Protective Services is involved, the prosecuting attorney who represents CPS. You have a circuit court judge, and you can have a CASA, and we'll talk about CASA before we end today. There's a multidisciplinary team that's made up of all of those people that we just listed, plus any treatment providers. So whoever's providing, mental health services, adult life skills, parenting services, transportation to the family, they can all be involved in the multidisciplinary team. We have school personnel that come and therapists and things like that that can be invited to come to the team. And we meet on a regular basis to look at the comprehensive plan that we're creating so that hopefully children can return home to their families. And that's the goal. The goal is reunification in all of these cases, and we work that goal of reunification up until it becomes clear that the parents are not going to be successful. So the first hearing that we have, the filing of this petition, this is where the allegations against the family are going to be listed in a formal document and filed with the court. And then we go into a preliminary hearing, which should occur within 10 days of the removal of the children. And the judge is going to be looking at, are these allegations serious enough and meet the definitions set in the law? Is it safe for the child to live with the parent while we're working on these things? And if not, then, will we have visits and that type of thing? The adjudication hearing is going to be set out after that preliminary hearing. Usually we have an MDT meeting. We talk about, what are the allegations? How serious are they? What are the next steps that mom and dad need to do? How are the children? Are we getting visits set up? That type of thing. And then we have this adjudication. This is the opportunity for the department to put on the evidence regarding the allegations that contained in the petition. So if we're making allegations about maybe a chronic neglect situation, what things happened in that situation created imminent danger for these children. So how long did they go in this chronic neglect? What services were offered? The parents didn't follow through. We're concerned about drugs. They might put on evidence of, drug screens, things like that. And then at the conclusion of the hearing, the court's determining whether or not the child has been abused or neglected, and therefore are the parents abusive or neglectful parents. And the parents have an opportunity then to present their own evidence. They can testify. They can, answer. Give their side of the story on any of these allegations. I keep using these words, improvement period. Improvement periods are the time frames that we give parents to make substantial change in what's happening. Remember, it takes a lot. One of the things that I hear from people is that CPS didn't intervene. I felt like they should have intervened, but they didn't intervene. It takes a lot to get your kids removed. CPS does a lot of stuff behind the scenes before children are even removed. They're working with a family. They're trying to create the safe home environment for children. Once the removal has occurred, there is going to be a set kind of expectations that mom and dad need to do. One of them is going to be to get rid of their drug habit. So they're going to need to go to treatment and continue with treatment during the duration of the improvement period, pass clean drug screens. We're also going to encourage them if they need, it's individualized. So do they need parenting classes? Do they need to access resources in the community so that they can set up an appropriate home? Do they need to clean up their home, get their, like I talked about earlier, get their gas turned back on, water on? Do they need some help with adult life skills? We might help them go through the process of getting a job or going back to school. What are the things that we need to do to help set this family up for success down the road? Do they need to lose would be a good way of saying it, but leave an abusive situation? So, is it a bad boyfriend or bad girlfriend situation? We need to get them out of that. So maybe we send them to domestic violence counseling or classes, that type of thing. We have relationship education programs that we send a lot of our families to. But these improvement periods are have a time frame. So as you'll see, I think on the next slide, everything in child welfare system has a time frame because we don't just let children linger within the foster care system. So a pre-adjudicatory improvement period is going to be 90 days long. Post-adjudicatories are 6 to 9 months, and post-dispositional would be 6 to 9 months. And that just means where it's falling within the process of the hearings. Dispositional hearings are going to be the hearing in which we address what happens to the care and custody of these children. This is at the end. This is after your improvement period. Have you satisfactorily completed it? And we're looking at reunifying the child and dismissing the petition. Or have you not satisfied your improvement period? Have you refused to do services? Are you unable to address your drug addiction, mental health problems? Are your children not going to be safe with you? And then we might be looking at alternative dispositions like termination of parental rights or placing your child permanently with someone else. So I told you that we're time limited reunification services. And then just in general, this just means that a child who has been in foster care for 15 out of 22 months, the DHHR has to seek termination of parental rights or document a compelling reason not to seek the termination. This is because we used to, in our history of the child welfare system, have cases that just lingered in the foster care system indefinitely. Kids were in foster care for a lifetime, and that's not the goal. Children deserve permanency and stability. So we have a 15 out of 22 month time frame. So why do people abuse and neglect their children? At some point, all families encounter change, stress, maybe even crisis. A family moves, a parent's laid off, childcare arrangements fall through, a step family comes, the car breaks down, a kid gets ill, the rent goes up, it goes on and on. And the families that we encounter in our work, by definition, are probably under stress and likely to be in crisis. So some families cope well with that and they adapt effectively to stress and crisis, and others do not. They become overwhelmed. Families that are not able to cope are often isolated from resources. They face a variety of challenges. They're stressed by numerous problems and they kind of compound on one another. And these families can develop patterns that lead to and then perpetrate abuse and neglect. There is rarely one single cause of an abuse or neglect. There's lots of risk factors involved: child-related factors, parent-related risk factors, social situational factors, family factors, and then triggering situations. And many times these factors coexist. So let's look at them. Risk factors. So chronological age of children, 50% of abused children are younger than 3. 90% of children who die from abuse are younger than 1. Firstborn children are the most vulnerable. Sometimes we just have a mismatch between child's temperament and their behaviors and the parent's temperament or expectations. We know children with physical and mental disabilities are at higher risk for abuse and neglect. Attachment problems or separation from parent during critical periods or reduced positive interaction between parent and child create risk. Premature birth, illness at birth can lead to financial stress, problems with bonding, parental feelings of guilt, failure, inadequacy. Unwanted children or a child who reminds a parent of their absent spouse or partner. These are all child-related factors. So other risk factors when it comes to the parent: low self-esteem. Neglectful parents often neglect themselves. They see themselves as worthless. Many of our parents that we work with have been abused as children. They may repeat their own childhood experiences if no intervention occurred in their case. and they don't have any new or adaptive skills learned. Depression may be related to brain chemistry or the result of having major problems and limited emotional resources to deal with those problems. Abusive and neglectful parents are often seen and considered by themselves to be terribly depressed people. Impulsiveness, abusive parents often have a marked inability to channel their anger appropriately. Substance abuse, drug and alcohol serves as a temporary relief for problems that are going on, but then in fact it creates bigger problems. Certainly psychiatric illnesses, personality disorder type things are increased risk factors. And then just really not understanding child development. They may have completely unrealistic expectations of a child. Family factors in here, domestic violence. Children can be injured while trying to intervene to protect the battered parent. Domestic violence indicates, one parent has an inability to protect the child from another, the other parent's abuse because that parent is also being abused. It, can create a large risk there. Research shows us that blended families are at greater risk. Single parents are also highly represented in abuse and neglect cases. Economic status is typically lower in these single parent families, and the single parents are at a disadvantage of trying to perform the functions of two parents. Adolescent parents are at a high risk because their own developmental growth has been disrupted. They might be ill prepared. They might not have great support systems. All right, and so when you have all of these, or a variation of these different risk factors, then we have what are these triggering situations? What is the situation that occurred that actually, got someone to call CPS on you? So, you have, these risk factors are contributing to a situation where the abusive event actually occurs. So some examples of these triggering situations: a baby that doesn't stop crying, frustrated with toilet training, an alcoholic is fired from their job, domestic violence situation where they can't reach, their support system, an eviction, stopping a medication, law enforcement is called out to the home, by the neighbor or someone else helping to intervene, and then a parent, who had a bad day then takes it out on the child. So all of these situations then lead us into CPS coming out to the home. So mental illness, a lot of our cases have mental illness involved. We have 1 in 5 adults in the United States suffering from diagnosable mental disorders. Of course, most of them do not have abuse and neglect cases. Mental illness is treatable. I think it's just important for us to think about the fact that many of our families do not have the resources and coping and don't follow through on their treatments, and mental illness can be a high risk factor. Talked about domestic violence. Child abuse and neglect occurs. Child abuse occurs in 30 to 60% of domestic violence cases. Substance abuse and addiction. This is really what's plaguing our state right now in our child welfare cases and why they're so high. I think easily 90% of my current cases have substance abuse as one of the top 2 problems. So the research that I did in creating this training talks about that substance abuse along with poverty are the biggest challenges for families in the child welfare system. More than half of children in foster care nationwide have parents with substance abuse problems. 80% of substance abuse related cases, in 80% of the cases, severe neglect is the problem. So they're using their drugs, they're using their money and their income on their substances, and they're unable to then take care of the basic needs of their children. Effects of substance abuse on parenting. the parent is emotionally and physically unavailable to the child. Their judgment, protective capacity is seriously impaired. The substance abusing parent might disappear for long periods of time, leaving the child alone or with someone that's unable to meet their basic needs. Their income is spent on drugs and alcohol, depriving the child of basic needs. You know, the not having resources leads to the unstable housing, which creates frequent school changes, loss of friends and support systems, and everything that's important to children. And then, of course, children's health and safety can be jeopardized by criminal activity associated with the use, manufacture, and distribution of drugs within the home. And certainly this group of you guys understand the prenatal exposure problems that impact children's development. So while abuse and neglect occurs in families at all socioeconomic levels, poor children are more likely to come to the attention of the child protective system. The majority of the kids we encounter in our cases are living at or below the poverty level. And so it's helpful to understand the realities of poverty so that we can be better advocates for our families. It's important to know, you know, like I said, socioeconomic, race, ethnicity, group membership, none of those things indicate someone is more likely to be abused and neglected. That abuse and neglect happens across all, but they're just more likely to be known. And that has a lot to do with the access to resources. So, you know, I'm able to tap into my family systems and my friend systems and access the resources to help me in situations where my children are at risk. All right, so I told you I'd tell you what CASA was. I couldn't let you go without letting you hear a little bit about what we are if you haven't heard of us. CASA stands for Court Appointed Special Advocates. We are a network of programs across the country who advocate for children in the foster care system. So here in West Virginia, there are 10 programs serving 31 counties. And my program specifically covers Ohio, Marshall, Wetzel, and Tyler counties. We train volunteers to advocate for children in the foster care system. Every single one of you guys could be a CASA volunteer. You could give 5 hours a month to get to know a child well enough to advocate for what happens in one of these cases. We provide comprehensive training for our volunteers so that you feel like you're supported in your journey. I know I have several volunteers. I saw you guys signing in that are on today, and our volunteers are amazing. They go and they meet with the kids, they get to know them, they talk to their schools and their medical professionals and the therapists. They make recommendations about what type of services families should have in their improvement periods. And then they monitor the improvement period to let the judge know how mom and dad are doing and when these children are ready to return home. I gave you 2 websites there to check out if you want some more information about us. All right, so how can you help report a suspected abuse and neglect? It's okay if, you know, CPS says everything in this house is, you know, doesn't meet the definition for us to intervene. CPS, that's their job. And that's what I love about my job is that I can be concerned and I can put it in the hands of CPS and they're going to go out and do their job and they're going to determine whether intervention should occur. And then I tell everybody, make sure you spread the word about what we're doing. And, you know, if you're working with anyone who could use additional training in mandated reporting, please send them my way. So let me stop there and see what kind of questions we have. I'm going to go to this and leave that up while we talk about any questions you guys have.
So we had one here, Susan. Do you have volunteers in Randolph County for CASA?
Randolph County, I don't think so. No, we do not have anyone in Randolph County. If you go to wvcasa.org, you'll see which counties we do.
There was one note also, family functioning assessment has been changed back in policy as initial assessment, although our fax system and the web system still say family functioning assessment.
Oh, you gotta love it when we're not all using the same language yet, huh? We'll get there.
Another note about Taylor, but you do Ohio, Marshall, Wetzel, and Tyler. Is that right, Susan?
Yes, Tyler, not Taylor.
What if you see some, oh, sorry, go ahead.
No, I was just saying Taylor does not have a CASA.
What if you see someone in a parking lot hit their child in the care and in their care and speed off, or see someone hitting their child in the mall?
That's something that I get asked a lot about. One is it abuse and neglect? I mean, from what you're able to see, one, you have to be able to provide the CPS contact information for them to intervene on, right? They need to be able to, you know, figure out who this person was. So likely that's not. Second, hitting your child is not abuse. Corporal punishment is not abuse. So I know that some of us don't agree with spanking or but it wouldn't meet the legal definition if you saw a mom slap her child or things like, you have to leave, you know, an injury on the child. So certainly if you saw something that was super, super concerning and, you know, someone was just wailing on their child and closed fist punching their child in the parking, I would call 911. They're going to be ones to report quickest.
So Susan, when you talked about that initial checklist of information that you might need when you call for a report, is there an easy way to kind of find that checklist or have it so that you would make sure you have everything you need before you make the call?
Yeah, I mean, I saw on Team for West Virginia Children, their website, and I'll go and pull that one up so they can see those websites. I actually saw on his slideshow they have several slides that have like very comprehensive lists of things that you could, you know, and I think even the form that they're filling out is on their website. So I would go there if you really wanted something something to print out and have in your hand.
Any other questions for Susan as we're wrapping up? Thank you, Mindy. She's putting some program information in the chat if you're interested in referring to that. NYAP and JVOM. Is there enough CASA volunteers for everyone who wants one, so that everyone who wants one receives one, Susan?
Oh Lordy, no, not even close. not even close. I think probably nationwide we're serving about 30% of the kids in care. So Roxanne, if you live around me, you can come on over. We need you.
So if a family would like an advocate but is not in a county that offers one, Susan, what would you recommend?
I would be contacting that child's guardian ad litem. So remember, CASA only is involved in the cases that are in the court system. So we don't get involved in family court situations or, before a case is filed during CPS intervention. We're not involved in those cases at all. Not until the court is actually involved is CASA involved. So if you don't have a CASA, the closest thing you have is a guardian ad litem for the children. And I would make contact with that child's attorney.
So we don't offer, there's a couple of questions about some housekeeping. We don't offer CEUs for this session. If you need a general certificate saying you attended, I'm happy to provide those. So I put my email in the chat. I can do so again, just reach out and I'm happy to get those to you. As long as you registered and I have your email there, I should be able to get in contact with you.
Yeah, if you're interested in starting a CASA program, again, if you go to the CASA website, wvcasa.org, you'll see the information for the state director. There's a link on there that says, I'm interested in helping get a CASA program started. But yeah, you have to go through the court system. CASA doesn't exist without its judges. The judges have to be the ones that want CASA.
Okay, I see that we're going a little past time. Any other time for one maybe final question? Okay, well, thank you all for joining. Our next Community of Practice for Impact will be on March 1st from 3 to 4 p.m. And we'll be talking about oral health in relation to neonatal abstinence syndrome and families and caregivers. Again, thank you all for attending. We appreciate your time. Susan, if you've registered for the session, I should have your name and email there. If not, and you want to message it to me in the chat, that's fine. Okay, I got it, Susan. Thank you. The person that posted from their iPhone about the certificate, can you either chat your name so I can see who to attach that to? Or if you want to unmute, that's fine too. I got it, Jeannie. Thank you. Yes, Stephanie, I got your email address. Thank you. All right, thank you all. We'll talk to you in March. Hopefully, go ahead and register again, and happy to have you. I got it, Jeannie. Thank you. Thanks, Susan. That was really good.
Good. All right.
Yeah.
I was hoping that was what you were hoping it would be.
No, I
Oh,
think it's
okay.
great. I think anything, and I kind of like how you gave how it actually works through it instead of maybe all the specifics, because you gave the link and you know what I mean? So I think just the
Yeah.
whole process is like, for me, I would.
Well, mandated reporting is a 2-hour training in its own right.
Mhm.
So, I mean, I can't do mandated reporting without 2 hours. I mean, so just being able to say, quickly who's responsible for reporting.
Mhm.
But, being able to help walk them through what CPS system that process looks like, I think is helpful to social workers and health providers and things like that. They get so frustrated with the system and what we're doing, and they're not responding fast enough, or but they don't understand what it is that CPS is looking for. They cannot intervene on every case of at risk.
Mhm.
That's what community resources are for. CPS systems shouldn't be involved in every case of at risk.
Mhm.
So
Yeah.
good. All right. Well, I hope you have a good rest of the day. Enjoy the sun if you get out there.
All right. Thanks so much. Talk to you
Okay,
later.
bye.
Bye.